State versus Robinson. Each party will have 15 minutes to present your argument. The appellant may reserve up to 5 minutes for rebuttal. If you wish to reserve rebuttal time, let me know when you begin your argument. I'll do my best to apprise you of your time, as I will be keeping track of the clock. The arguments are being visually and audibly recorded. Don't use the names of any victims in this matter, and we have read your brief. We are ready to proceed when you are, Mr. Cartwright-Jones.
Your Honors, Mr. Murphy, pleased to meet you all under these circumstances. And at first, by the way, my name is Reese Brendan Cartwright-Jones, bar number 0078597. And when we began this case, by the way, also I'd like to reserve 5 minutes for rebuttal.
Okay.
When we began this appeal about this time last year, I don't think that it was thought by any of us that we would be addressing the subject matter that we are addressing, which involves police use of force, under the circumstances that we are addressing them, in a more historically appropriate time, both the way we're doing it and what we're talking about. Police use of force could not be, I think, more present in U.S. consciousness than it is now. So there are 5 assignments of error here. I understand that the court has read them. I would posit that 3 of them are so closely related that we can address them as one. And those 3 assignments of error would concern the Castle Doctrine instruction, sufficiency of evidence, and the manifest weight of the evidence, all of which really turn on the aspect of what circumstances are we dealing with when somebody is in his own home and apprehends any kind of a threat or use of force. The other 2 assignments of error concern speedy trial and, somewhat related, a request for continuance. But really beginning with, I think, what is the sine qua non of this case, just due to the fact that it involved Martin Robinson in his own home when all of this happened relative to the service of a Cuyahoga County warrant, at the trial of this matter, merited a Castle Doctrine instruction. Why? He was in his own home. The plain text of the applicable statute concerning the Castle Doctrine, 2905.01, indicates that if there is any evidence that tends to show that the defendant was in his own home acting in self-defense, then we provide instructions that the state bears the burden of proof in showing that he was not acting reasonably in self-defense. It is not a sufficiency burden. It is not a manifest weight burden. It is not even a burden of production. If there is any evidence that tends to exist to establish any element of the Castle Doctrine, then that is the way the case proceeds, and that's the instruction that must be read to the jury. I would posit that this is not a case that involves any requirement of an affirmative defense, either by way of Mr. Robinson and his counsel showing sufficient proof to establish an affirmative defense or anything like that. The simple fact that he's in his home puts the elements of revised code section 2905.01b1 into play, and that's the way the case should have proceeded to the jury. Now, insofar as the government at trial said, A, this is absolutely not merited, and B, we're not going to attempt to prove anything along those lines, then that element is missing, and I think that forms the basis of a sufficiency claim. In other words, the government had to prove, as an element of its case in chief, that Mr. Robinson did not act in self-defense within his own home. Of course, the government opted in its strategy not even to address that element. That element was not proven, it was not given to the jury. So there are 2 remedies that I'd posit are appropriate. Either A, this case should be retried before a jury with a Castle Doctrine instruction, or B, because the prosecution just declined to address the matter altogether, then I think this case could and should be disposed of on a sufficiency challenge. It is, though we're talking about a new doctrine, though there is a fair amount of case law from both sides on that doctrine, I think the issue is as simple as that. The last thing I'd like to point out on this issue, after all of the briefing was submitted, this court decided, I want to say it was February 24th, the matter of State versus Claren. And I didn't submit a notice of supplemental authority because State versus Claren drives home the same fact that we're talking about. If you're in your own home, by the way, the circumstances on State versus Claren involved a man on his own front porch or front stoop, the Castle Doctrine instruction comes into play. That element is there. It's apparent. It could not be simpler than that. And I think that that ties up those three issues in one package. The only question is the remedy. And I posit for the reasons that we did, that it is either retrial with letters of correction instructing the court to retry the matter with a Castle Doctrine instruction to the jury, or because we're missing an element, just dismissal for failure of sufficiency. So that leaves us with two more issues. The issue of speedy trial, which breaks down to really when does the speedy trial clock begin, and then the issue of the continuance. So let me start in order of the brief with the issue of speedy trial. I think both the state and I agree that the big question is whether or not this case begins with the arrest at the scene of the affray of Martin Robinson, or whether it begins with the September indictment of Martin Robinson. Both the state and the defense cite the matter of State versus Asbell. Asbell lays out, by way of the state Supreme Court, a bunch of different elements for when we determine whether a speedy trial clock begins on a date. And I'll give the state its language here. I am not going to right now call it the date of arrest, but let's call it the date of apprehension or the date of taking into custody or what have you. So then the question under State versus Asbell becomes, was Mr. Robinson taken into custody pending the filing of charges? I cannot imagine, and though of course the state only has the benefit of filing its answer brief, I cannot imagine that the government is going to say, well, yes, we recognize the plain language of Asbell, that speedy trial begins to run from Mr. Robinson when he was taken into custody pending the filing of charges. What could the response be? Well, after a case that involved the shooting of a police officer, we took him into custody, but we were going to let him go. I can't imagine that. So I might say I'm somewhat interested in the response there. But yeah, I mean, under that element of Asbell, obviously time under revised code section 2945.71C begins to run on the date he was taken into custody after the whole affray at his house. Now, the next thing that the state points out is, wait a second, this whole matter involves a capias warrant out of Cuyahoga County. And actually, I believe it's two capias warrants. So was he held on multiple charges such that he would not benefit from the triple count provision of chapter 2945.71 of the revised code? He does, and here's why. At least legally speaking, what do we have with speedy trial? In your brief, in our briefs, I think both of us recognize that there is a burden shifting process. The defense burden is essentially, hey, this took too long. Count it 270 days or 90 days for incarceration without tolling events under revised code section 2945.72, and we have a colorable claim of a speedy trial violation. We certainly have that here. Anybody who counts the calendar days in any direction can recognize that, that there are too many of them under the speedy trial statute. That shifts the burden to the state to do a couple of things, one of which the prosecution did here, which is to argue over the date of arrest. Well, I don't think there's any question under the date of arrest. So the next question is tolling and the triple count provision. True, once we deal with motions for competency and substitutions of counsel and requests for new pretrial dates, those events toll. But the state's, I guess, sort of last leg of an argument is that we should be on a 270-day clock under revised code section 2945.71 because Robinson was not held on, excuse me, because Robinson was held on multiple charges. The record isn't clear on that. The only thing we have is that there was a capious warrant and it existed. In the trial transcript relative to the motion to dismiss for speedy trial grounds, there is some discussion of 2 capious warrants, but there is no discussion of what happened subsequent to those warrants. Were they valid? Did the case even continue? Was it dismissed? Which, by the way, eventually it was. This court could take judicial notice of same by way of the Cuyahoga County docket. But we're confined to the record in front of us, I would posit, and the only thing we have is that a capious existed. We don't know whether or why he was held subsequent to that capious warrant as far as the record's concerned. I understand we can guess, I understand we can surmise, but there is no record that would support a finding of a single day count provision rather than a triple count provision. To
Counsel, excuse me, I just want to let you know you're at your 5 minutes. You're welcome to keep going, but I just want to let you know.
Thank you, Your Honor. I'll wrap up very quickly. The last thing, as far as the continuance, that continuance is a malicious request that a defendant substitute his rights to effective assistance of counsel versus his right to a speedy trial. The court's only reason for denying that continuance was because there was no speedy trial waiver. First of all, I don't think that's good grounds. I think it's a rank abuse of discretion. We can analogize this to the 7th District's case of State versus Reber. And finally, as a matter of fact, I'll reserve the rest of my time for rebuttal. Thank you.
Well, counsel, I have to ask you a question on that last thing. You be the judge. What do you do?
Oh, on the continuance issue?
Sure.
I grant the continuance, even if.
All right. Now you be the appellate judge.
So I put myself with empathy in your shoes, Your Honor.
And now you're here arguing speedy trial as strongly as you are arguing it.
No matter what, under revised code section 2945.72, the continuance would count as a tolling event under speedy trial. That does not impact the merit one way or another of a speedy trial clock. By the way, that continuance would inure in favor of not dismissing the case on speedy trial grounds. But by the way, to be very clear, I'm not going to be so disingenuous as to not say that there are tolling events following the September presentment of this case. Revised
okay,
code,
so you're saying because he asked for the continuance, it's not.
Absolutely, and that's that.
It goes against him.
Yes, Your Honor, and that's in the plain text.
Gotcha.
Yes, Your Honor.
Gotcha.
Yes.
Okay. Thank you.
And what I have left of my time, I'd just like to reserve for rebuttal.
Okay. Mr. Murphy, give me 1 minute. I want to write a note here.
Sure, Judge.
All right, whenever you're ready.
Good morning. Brian Murphy, Assistant Prosecuting Attorney, Lorain County Prosecutor's Office. The state is asking the court to affirm the trial court's judgments and Mr. Robinson's convictions in this case. With regard to the speedy trial violation, the first assignment of error, Mr. Robinson's speedy trial time did not commence on June 2nd of 2018 after an arrest on June 1st of 2018. And that's because he wasn't a person against whom charges were pending under ASBEL, which I'd note Mr. Robinson did not, according to my review of his brief, even acknowledge in his merit brief, his initial brief. I did in the reply brief, of course, replying to our raising it, but not in his first brief. The revised code section 2945.71C1 specifically says a person against whom a felony offense is pending must be brought to trial within 270 days of arrest. There's no doubt that Mr. Robinson was arrested during the early morning hours of June 1st, 2018, but he was not a person against whom a felony offense was pending at the time. An arrest is not enough. It needs to be an arrest in connection with those charges. he was not formally charged by complaint or indictment at the time. He was not held by Lorain County authorities pending charges. He was turned over to Cuyahoga County on the warrant. That's why they were there. And obviously he wasn't released on bail or recognizance. This is Asbel. The court here, this court has also relied on Asbel in the Wheeler case cited in the state's brief. And really what the state is essentially saying is Lorain County's, contrary to what Mr. Cartwright-Jones thinks we would say, we are saying he was released, let go, but with the full knowledge that he was going to remain in Cuyahoga County's custody. The burden was on Mr. Robinson to show that he was being held, that he had been arrested and had a felony offense pending against him, that he was a person against whom a felony offense was pending, and he failed to do that. He was, we'd also note that the triple count provision that's been cited first, and this is the court's recent case of State versus Kuykendall, it was his burden to show that he was entitled to the triple count provision, his specific burden to do so, and that he didn't do that. He was arrested after an indictment that came across, or the grand jury handed down in September. He was arrested December 18th of 2018. That's when his speedy trial time began to run in this case. And obviously December 19th of 2018 until January 15th of 2019 comes up well short of 270 days or 90 days, even applying a triple count provision. With regard to the last assignment of error, the continuance, I do want to point out that in the state's brief on 19 and reviewing for the argument here, it does say that the trial court, quote, declined to give a particular jury instruction. That should say decline to grant a continuance, and it's consistent with the case law that's cited there in that sentence. Again, we're reviewing for, this court reviews for an abuse of discretion. I was a little unclear from the state's perspective what continuance that Mr. Robinson, or failure to grant a continuance Mr. Robinson was objecting to, because there were several. There was the initial one on February 7th. I think that's pretty clear that there was no abuse of discretion. That's the date that Mr. Yoder entered the appearance and at the same time concurrently filed a motion for a continuance. He told the trial court, though, on that date during a hearing that he didn't expect to continue representing Mr. Robinson, and therefore his request for a continuance, I think, was reasonably denied. And there were renewed continuances on the day that the trial was set to begin and the day before. So I should say the day before trial was set to begin and the scheduled date of trial, February 19th and 20th. I think, as Judge Callahan noted, what was the trial court supposed to do under these circumstances? Mr. Robinson, at no point, except one very brief moment, indicated that he was prepared to accept a continuance of the scheduled trial date. Throughout the course of these proceedings, Mr. Robinson was steadfast that he intended to have this case tried within the statutory speedy trial time. Interestingly, it was his attorney requesting a continuance. The record never reflects that he was requesting the continuance really on his client's behalf. And whether that's appropriate or not, that's not really the issue before the court, but it seems more that the trial court was actually preserving Mr. Robinson's desire to have the case tried within that statutory speedy trial time. Mr. Robinson simply didn't want any delay in his trial. And it was going to be a significant delay based on trial schedules of state's trial counsel and of the trial court. And that's, I think, goes to Judge Callahan's point of if the trial court does grant a continuance, it's going to be well out. And then does Mr. Robinson eventually possibly try to withdraw the motion for withdraw the waiver? And now the parties are stuck in a place where it potentially brings great upheaval to the trial court's docket at that point. And in fact, the continuance is coming because retained trial counsel wants more time to prepare for trial. Look, Mr. Robinson's the one who brought trial counsel into the matter just less than 2 weeks, 13 days before scheduled trial date. It was clear that Mr. Robinson never intended, he didn't want any extension of the trial date. And that his lawyer really knew that going into that initial hearing on February 7th. It's the state's position that the motions for continuance were reasonably denied. It was a sound decision. Addressing the second assignment of error, the jury instructions specifically relating to self-defense. Again, the standard of review here is an abuse of discretion. I'd like to preliminarily address revised code section, and let's be clear, this is 2901.05. It's not 290501, which is a kidnapping statute, B1. So Mr. Robinson cites to 290501, and he also stated that during the argument here that's in his brief at 10. This is a self-defense issue. This is not a Castle Doctrine issue. The Castle Doctrine is not under 290105. It's under 290109. And under 290105, self-defense, that's the jury instruction that Mr. Robinson's trial counsel sought. Look through a multi-volume record, and I don't believe that you will at any point see the term Castle Doctrine or the revised code section of 290109 brought up even once in the entire, I believe it's 12-volume transcript of these proceedings. So this is an argument being made for the first time apparently at the appellate court level, and this court should not condone that. It's not the issue. And even if you did want to raise it, the Castle Doctrine requires the person to lawfully be in the residence. Once the police arrived with an arrest warrant, as the state notes in its brief, the police did have the ability to go into the residence under revised code sections. If this comes down to an issue of self-defense, it was and by the way, 290105 as cited, albeit under 290501B1, the particular section cited by Mr. Robinson in his brief didn't even take effect until March 28th of 2019. That amendment, of course, occurred well after the incident occurred, after the jury returned its guilty verdicts and after the date of sentencing. To raise an affirmative defense, this court knows the standard. The evidence must be of a nature and quality that sufficiently raises the issue. It must give rise to a reasonable doubt of guilt, not speculation or possible doubt. If it's speculation or possible doubt, the court should not and doesn't abuse its discretion in not providing the jury instruction to the jury. It's the defendant's burden to produce the evidence of self-defense and to prove the self-defense by a preponderance of the evidence. This was deadly force, of course, that Mr. Robinson used in his claimed self-defense, but he can't satisfy even the first element, which is that he wasn't at fault in creating the violent situation. Mr. Robinson didn't surrender. police repeatedly asked him to surrender peacefully, and he disregarded those orders. He was repeatedly informed that he wouldn't be hurt, and the overwhelming evidence is that he fired first. The only evidence that he didn't fire first was the quite quizzical testimony of the neighbor, J.G., who said that police kicked the door down instead of using a battering ram, which multiple witnesses testified. Then the officer walked down the steps and went toward a window, and then law enforcement fired first. That needs to be balanced against her testimony that this MRAP, M-R-A-P vehicle was not in the, she testified that this humongous vehicle was not in Mr. Robinson's front yard when the shooting unfolded. Now, there were two other neighbors who said absolutely, multiple other witnesses who said that the MRAP was in the front yard. And also, it should be noted that JG's behavior at the scene led to her being charged and ultimately convicted by her own testimony of misconduct and an emergency. Her testimony was incredible. It was frankly bordered on unbelievable and was not sufficient evidence to support Mr. Robinson's claim of self-defense. Mr. Robinson's testimony itself also didn't submit his claim, support his claim of self-defense. At first, he even claimed that he didn't shoot at officers. Now, by claiming he didn't shoot at officers, he's denying that he acted in self-defense. Now, eventually, he does say he shot through the front door, that his life was in jeopardy. He believed that was on direct examination because when you review the transcript, you see that he becomes basically non-responsive on cross-examination, repeatedly stating he didn't know, he didn't recall. His testimony only gave rise to speculation that he acted in self-defense. Perhaps not even speculation. It may not even rise to the level of that, but it certainly doesn't give rise to reasonable doubt, beyond a reasonable doubt that he was not reasonable doubt of his guilt. His own testimony doesn't support that. He also fails to show that he had a bona fide belief that he was in imminent danger and that great bodily harm was going to occur, and the only way was to use force. There was an arrest warrant for him. He could not escape. He was not in imminent danger. Police simply wanted to take him into custody and proceed with the matter in Cuyahoga County. It was unreasonable to believe he would be harmed at all, as he was repeatedly and continually told that he wasn't going to be harmed, and was urged to surrender peacefully. I noted a revised code section that's 2935.12a, which allows law enforcement to use force to enter a residence with an arrest warrant. Law enforcement, in fact, never entered the residence. They did reach the door, but never entered the residence. A self-defense instruction was not warranted. Mr. Robinson's argument at the trial court level was self-defense only. It had nothing to do with the Castle Doctrine. And based on that self-defense argument, obviously the sufficiency argument can't stand. And if the self-defense argument fails, then the manifest weight from the state's evidence position becomes moot.
Thank you. With that, your time is up.
Thank you, Judge.
All right. You still have 3 minutes.
Thank you. I will be very prompt. State's counsel argues that Castle Doctrine appears nowhere in the transcript. Again, nowhere in the transcript. It's absolutely false. Page 1763 of the transcript, the court on before this court, it's a proper issue. Even if it weren't raised at the trial court level, This court's
Can I ask
decision.
a question?
Yes.
Excuse me, I have a question.
Yes, please.
To